All right, hey guys, welcome. Thanks for joining here on Thursday. We got 1 hour. We're going to try to crank through as much as we can here in terms of giving you guys some estate planning 101 and also giving you guys a chance to ask questions. And here, I think Cody's got a great story about his company and what they're doing to make estate planning really accessible and just frankly easier for everybody. Let me get rolling through our slides here. So again, this is an MIT Club event, and the mission is to further the well-being of local MIT alumni. So we do events like this. They're volunteer-led. It's an opportunity for other people to get involved. It's 15,000 plus alum. We have a number of tracks. I'd love for you guys to get involved. We're part of the Fin track, or the Finance and Fintech track, and we have an exciting event coming up on Saturday, and I want to give Dawn a chance to talk about it because not everybody understands why it's called the swim test training. And before I turn it over to Dawn, if you guys are interested in FinTech for today's event, raise your hand or hit the hand raise button. Or if you're interested in estate planning only, keep your hand down, because that'll help us sort of decide how much time to dedicate for each section. So go ahead and fire away, and then Don, I'll turn it over to you. Tell us what's going on Saturday.
Hi, everyone. My name's Don Haina, and if you were not an undergrad at MIT back in the day, they had a swim test, and you couldn't graduate without passing the swim test, which I think was treading water for 10 minutes. And so I named this event the Passing the Financial Swim Test. It's going to endeavor to teach you all the things you should know to keep your head above water and make intelligent life investing decisions. And so I'm looking forward to that. It'll be Saturday at 11. We'll go for 2 blocks of about 40 minutes with some time in between. Hope to see you there.
All right, thanks, Don. We got other events coming up, and get involved, folks. Let's put on more things. So we have a limited amount of time, but here's what's going on. This slide kind of tells us that people don't have an estate plan. So, and anytime you talk about fintech opportunities, they talk about this intergenerational wealth transfer. But well, guess what? Here's a company that's right in the nexus of it all, and Cody is gonna tell us about that. But before I hand it over to Cody, really the biggest barriers to getting yourself organized is it's right here. It's education, it's procrastination, and then you got to find somebody, and then you're still going to procrastinate. And so hopefully we can kind of give you guys the information you need to check off number 1, maybe nudge you on number 2, and who knows about the rest. So I want you to come out of here at least knowing what it is, how it's relevant to you, and if there's anything you need to do about it right now. Okay, so we have 3 sections. We've got the fintech perspective from Cody, which kind of mirrors you guys. Like, if you don't have a trust yet, here's, Cody's a serial entrepreneur. I'll let him introduce himself some more, but he saw a huge market demand for this and built a company with his co-founders. And the number 1 success factor for a fintech is, there's an E&Y study a few years back, it's ease of adoption. That's the number 1 thing. It's not pricing, it's not custom, it's ease of adoption. And these guys, they just raised their Series B. It was announced 2 days ago. So they're killing it. They're clearly hitting that number 1 metric that matters. So anyway, so their head of legal, Patrick, is here. He's going to give us some estate planning 101 on that perspective. And then Barry, with 35 plus years of experience, can give us really more of the strategy side of things and go into some of the deeper, and I would say more interesting aspect of estate planning, like once you kind of get the blocking and tackling done. So I'll stop talking, turning it over. I'm going to turn it over to Cody here to introduce himself and tell us a little bit more about trust and will and estate planning in general.
Yeah, thanks, Jason. And thank you to everyone for making it out today. Just for context, I've been on the alumni board at San Diego State University for 4 years. And when alumni of other schools can put events on like this, but also get a great group to participate, it says a lot about your school spirit and your dedication, not just to yourself and your own profession, but to giving undergraduates the kind of commitment or the understanding of commitment of life back to the university. So a lot of respect. My background, I'm born and raised Southern California. I grew up in Huntington Beach, California. So Surf City, USA, used to have hair down to the shoulders. Now the hair's going back this way. But great place to grow up. Made my way down to San Diego 13 years ago for school, and really got involved at San Diego State. I was student body president my senior year, which gave me the unique position of being CEO of Associated Students. It's a $30 million nonprofit, an umbrella org to the university, and really got me understanding a deeper level of the endowment, the research foundation, athletics, just kind of full spectrum across the university. And that year was transformational for me because I'd never had so much opportunity to set a vision, get the right leadership team in place, get the right organization in motion to go and execute on that vision. And knowing that even though I was only in the role for 1 year, that it would be a multi-year effort to see those objectives come to life. And I think it was a great transition for me to becoming an entrepreneur. I've now started 3 companies, 2 of which are venture-backed. And this whole journey for Trustimul came up a little over 3 years ago, as I was kind of at a life's crossroads, a good one, where my wife and I were about to get married. We had kind of had a sit-down conversation at dinner, less fun than what most people would want to talk about over wine, but talked about our finances. So working with a financial advisor, talked about setting up life insurance, talked about taxes, and of course, we should probably set up a will. That's what responsible adults do. So this kind of casual conversation really led down to a very concerning effort into understanding the estate planning landscape. Why does it cost $3,000 to $5,000? Why does it take 3 weeks to 5 months? Why can't I do this online? Why aren't there trusted online partners to the size and scale of a TurboTax? So I realized I wasn't alone in these questions. And this conversation also was in the minds of my now co-founders. So Daniel and Brian have been friends of mine for many years, going back 6 years now, but kind of same life event. They're married. We all 3 of us are dads now. And just the whole mindset shifts that when you become a parent, there's certain decisions that you should be making to better protect your family and to set them up for the inevitable, right? There's always the chance that something comes up. I hope that it's not for a long time. And when we started looking online and started looking into the trust and estates industry, some of the points that Jason had on the previous slide were pretty concerning. That's the fact that half the population doesn't have an estate plan. And even the half that does, when's the last time they touched their documents? If their documents are in the garage, the attic, the basement, how much has changed? Did they have more children? Did they buy a new home? Did they move states? Did the Secure Act have an impact on their estate plan? These are strategies and conversations that I'm excited for Patrick and Barry to unpack much further in detail. But just at the surface level, why even have an estate plan? You're not required to, right? So I'll let Patrick and Barry go into probate and the benefits of a trust and all that. But really the ultimate ask was, well, why if no one's doing this, why can't we do it better? And why can't we build a best-in-class brand that's recognizable, a product that's easy to use, and most importantly is inclusive, that wealth does not have to be the trigger for having an estate plan. If you have children, you should be thinking about this. If you're a caregiver taking a loved one, you should be able to make medical and financial decisions on their behalf. And price too. Price should be mindful for a lot of families. Price shouldn't be a barrier to having an estate plan. And yeah, there's some times when Trustimul, an online solution, isn't the best fit, and going offline to a trust and estates attorney is the better decision to make. So 3 years ago, these were conversations and thoughts we were having. We thought we could do it better than anyone else, and have since been on this incredible journey the last 3 years. We've raised 23 million in venture capital from a rockstar group of investors, from your traditional household VCs to corporate strategics on banking and insurance. We've helped 160,000 families start this process, which we're really proud of. And more than how many families, it's the experience that they're having. If we share our reviews, we've always made our customer experience kind of a pillar of our company from day one. But having live chat available 7 days per week, booked phone support 7 days per week, starting to offer attorney support in several states, really giving people peace of mind that, yeah, you're going through, you're making some pretty serious and significant decisions, but there's always a human, despite us being a tech company, there's always a human on the other side. So we've always led with our values and this kind of family-oriented culture that we've built as we think through what the customer experience should look and feel like. And I'd say that more than anything is one of our proudest achievements as a team. We're 24 people strong. As Patrick had mentioned right before the group came into the room, all of us are based here in the US, but 23 of us are in San Diego, California. And we've just built a wonderful culture. Now, with this new round of funding that Jason mentioned, it really raises the stakes. It raises the bar, because while we've helped 160,000 families, there's tens of millions that have not started this process. So as we look forward to the next 5-10 years of the journey we have in front of us, there's a lot of families we can go help. There's a lot of organizations that we can work with. We're already working with big folks in financial services, insurance, and estate planning kind of touches a little bit of everything from those 2 categories to taxes, real estate, plan giving, healthcare, and even miscellaneous categories. So as we've gone down this path the last 3 years, we've started to work with some incredible partners. And our hope is that we go far beyond just the document creation. You're getting married, having kids, buying your first home, you're setting up the estate plan, which is a feel-good aspect. and a sense of accomplishment. But what about the rest of your life? It's not a one and done experience. I mean, Barry and Patrick are going to illustrate why over time you actually want to not just keep your estate plan up to date, but look at more creative strategies around benefiting you and your family, the tax implications that come along with this. And that's really the foundation that we're building for the next few years, is that we'll move into estate management. We have a product for financial advisors, which over 1,000 financial advisors across the country are using it to bring their clients into the Trust and Will ecosystem. It's more of a collaborative experience than anything. And then that long-term vision is to move into estate settlement, to think through what does a digital price inclusive product look like around probate, or what does it look like around professional fiduciary and trustee services. These are all big terms that when we started this journey, we didn't know much about. Patrick, of course, was the expert. He was our first hire we made 3 years ago. But now here 3 years in, and what the next 3 years of this journey look like, there's an opportunity to transform an industry, for Trust and Will to become the default option, the way that TurboTax is the default option for 30 million Americans to file their taxes. But of course, over time, we can increase the funnel to accommodate complexity, accommodate growing numbers of wealth. We have one thing that's really fun is I'll talk about is now our product is digital, and that's a good slide to be on, Jason. Our product is digital, but the documents, you have to print them. You have to print them offline. You have to sign them, notarize them, and execute them offline. Except the landscape, the regulatory landscape is changing. So in Nevada in 2019, we successfully completed the first electronic will in US history. In the state of Florida, you can now do an electronic will. So over the video call like this, you're doing a digital signature, digital notary, digital storage of documents. Really, in our minds, that is the future. It doesn't just benefit Trust and Will, it benefits folks in the traditional trust and estates world, that they can offer a digital execution for their clients. It's more inclusive. You can do it especially from the comfort of your own home with COVID going on. And where we originally thought that for all 50 states to adopt this, it might look like a 5 to 10 year horizon. Based on the pandemic and people waking up to this, it now might look like a 3 to 5 year timeline. So the products, without getting into the details, I'll save that for Patrick and for Barry to unpack. Our product is very, very straightforward. We've kind of unbundled the estate plan to make it accessible for the everyday family. Our trust-based estate plan is designed for the homeowner and wealth builder, priced at $499. Our will-based estate plan is kind of more of our one-size-fits-all. What most consumers will know of a will through family or pop culture. You have big blockbuster movies like Knives Out, priced at $159. And then for the first-time parent, and I feel like grandparents, new grandparents are probably pushing this product to their own children who are now parents. My mom's upstairs. Is Guardian. Guardian is a nomination of Guardian form. It is really just the quickest way to get the peace of mind as a parent without having to think through all the other decisions that come along with creating a will or trust-based estate plan. Last thing I'll mention here is that we have an inclusive subscription. So ongoing updates to the estate plan are really important to us, that you don't have to come in a year from now or 2 years from now and start from scratch. If you want to change the Guardian, if you want to change, you move states, you want to make these updates or make these changes reflected in the estate plan, we don't charge an arm and a leg. We try and make it as affordable and easy to do as possible. It just requires new signature, notary, and witnesses. So the attorney piece, I'll let Patrick unpack a little bit further. We do have customers with more complexity or assets that kind of exceed our self-service model. And the attorney option is giving true peace of mind that you're getting a trust and estates attorney added into the experience that can talk through tax implications, the funding of the trust, scenario modeling, and more. And last slide, which is the next one, Jason, we always lead with that customer experience. The fact that we have 6 team members on customer success available 7 days per week for chat, phone call, ping us on social media. We really take a lot of pride in being there for our members. And that's why we have one of the highest reviews of any online estate planning platform in market today. So I'm going to wrap up here and just say thank you. Thank you for letting me share a little bit more about our journey and where we've been, where I've been as an entrepreneur. Happy to open up to Q&A later, but Jason, I'll hand it back to you. Thanks, everyone.
All right, thanks, Cody. And yeah, I mean, AARP invested with these guys in the deal that was announced this week. So, anyways, it's not meant to be a commercial. It's meant to show you that there is new technology, there's new disruptive solutions out there. And again, procrastination is the biggest, barrier I think that I've noticed with my clients. And so that's why we're kind of, giving you all that extra information. So, all right, let's turn it over to Patrick and give.
Thanks, guys. Again, just like Cody said, I want to echo, thanks for having us here. We love to speak a little bit about what we do, and me personally, estate planning and why I think it's such an important topic. I was an estate planning attorney Got connected with Cody and the other founders at Trust and Will, and this was a perfect opportunity for me to address what I saw was one of the biggest problems, similar to what Cody was people who would say, I need help, and they would call the attorney, and the attorney would say, sorry, you can't afford me. And typically it's nicer than that. It would be, here's my hourly rates, and then they would hang up instead of the attorney hanging up on the client. But the result is the same. The inability to get the help you need from a trusted resource in an accessible and reliable manner. And that's really where Trust and Will comes in. I'm going to focus a little bit on the estate planning basics. We get a lot of questions about what is an estate plan, and some people have misunderstandings or limited understandings, and this is really foundational, fundamental, low-level knowledge. But we're happy to discuss further. If anybody has any questions, feel free to drop them in the chat. We'll definitely cover them as needed. So an estate plan is a set of legal documents with instructions for what might happen when you can't speak for yourself. The two primary times that comes into play are at death or incapacity, either time you're unable to speak for yourself. Estate plans will handle fundamental needs. These are needs that are important for everyone. Everyone needs to consider certain questions, but estate planning also provides an opportunity for some more advanced individualized planning. These are some techniques that might be useful for some individuals, but maybe not for everyone. So it's a little bit of a mix between everyone needs it and some people need additional options in there as well. When we focus on estate planning for death, that's really what a lot of people think about. And that's common. You know, estate planning is when you die and you have a will. And we have the next slide, Jason. And that's really, it's an important thing to consider. And it is something that, I mean, we all know how true it is. We will all someday die. But while we are living, we have this wide range of legal rights and responsibilities. And at your death, you cease to exist as a legal person. And that leaves a void. So do those rights end? Are they transferred to someone else? If so, to whom? And so you get some really important questions. I owned assets, I've died, who now owns those assets? Or who will care for my children? Or who will make legal decisions about my estate and the administration of my affairs? And so these are questions that everybody has to deal with throughout their lifetime. And if you don't have an estate plan in place, the state has essentially default rules that apply and make these decisions for you. But these are the fundamental questions that everyone needs to deal with at death. And this, when planning for death, it is a permanent transfer of legal rights. And it's important to realize that. And it's simple if you think about it. You're not coming back from death. And so we need to make a permanent handoff of resolving these questions and having someone else appointed to handle these rights. On the next slide, the second issue is kind of planning for incompetence or incapacity. And that's when you're still alive, but you're unable to make decisions for yourself. Maybe you're, suffering from a, cognitive impairment, or you're just simply unconscious in a coma, whatever the case may be. But who steps in to make those decisions and exercise your rights for yourself? Who makes medical decisions? Who consents to treatments on your behalf? Who will handle your financial transactions? I mean, just because you're unconscious, taxes still have to be paid. So who's responsible for filing those tax returns? And so estate plan also lets you designate a temporary representative who will speak for you while you're incapacitated. And as opposed to death, which is a permanent transfer, planning for incapacity is a temporary, kind of a gap filler. So it's just for that time that you can't speak for yourself, someone else can speak for you. So what are the documents involved in an estate plan? It's a set of legal documents, and the number ranges depending on your needs and the particular type of plan. But really some common documents that you'll see are the last will and testament, a revocable living trust, and a set of documents that are referred to collectively as healthcare documents or disability documents. That'd be the advanced healthcare directive, sometimes called a living will, a financial power of attorney, and a HIPAA authorization. And again, these documents, they do kind of vary. So your needs might need additional documents, or maybe you need fewer documents, but this is kind of the common set you'll see, but it's by far not exclusive. And so really just kind of covering the basics. A lot of people have kind of a Hollywood-based understanding of wills, and most of that's true, but you rarely have a lawyer sit in a room and open up the will with the big dramatic performance, Knives Out style. It'd be great if they did. It'd probably add some variety to the typical estate planning attorney's practice, but it's just unfortunately not a common occurrence. Wills really are a fundamental estate planning document. They're roughly 500 years old. The origins of the will date back to before the U.S. It's English law. These are designed to handle some really fundamental issues. And this is what happens to assets after you die, who will care for my children, and specifying your final arrangements. So this is these are things that, again, we've covered that everyone needs to consider these. And that's really what the will is designed to do, to handle those critical questions that everyone has to address. Wills are a little simpler. There's less of an opportunity for more advanced planning. And one major concern with the will is they go through probate. Most people are at least vaguely familiar with the concept of probate. It's bad. That's short end of it is bad. In California, it's typically a 1 to 2 year process, tens of thousands of dollars in costs. It's a public proceeding. It's an administrative hassle. You're dealing with all of this immediately after a death. It's just bad. So the fact that wills do go through probate is an unfortunate reality, but that is why so many people do turn to trusts. And when I discuss trust, I'm typically referring to a revocable living trust. There are other types of trusts, but the revocable living trust is really the workhorse of modern estate planning. It's a more advanced estate planning document. It's more modern. It gives you a little more control over some issues that may not have existed in the 16th century. The focus is really on assets, and instructions apply to what happens to your assets while you're living but incapacitated, and also after death. Trusts give you a lot of control over distribution of assets. You can set a lot of triggers for when do you want assets to be paid out to your beneficiaries and children, how do you want them paid out, what conditions, all sorts of things like that. A lot of control over that. And that also gives you a lot of opportunities for advanced estate planning, tax minimization, asset protection. Really, the trust, it gives you almost limitless control over being able to address concerns that are important to you. It's always a little bit of drawback depending on what you may do, but there's a lot of planning that can go into using trusts. But even for most people who don't have truly outstanding needs or just really, really unique situations, trusts avoid probate, and that is a huge benefit compared to a will. The other set of documents you're commonly going to see are the healthcare documents. The living will, sometimes, and its healthcare directive, or a few other names you'll hear. This really designates someone to make medical decisions on your behalf, a medical power of attorney. It also specifies what your preferences are for healthcare treatment and end-of-life decisions. This would be things like life support. Do you want to be on a feeding tube or not? You can speak these instructions in advance of your need, and that's a great opportunity to make sure that your preferences are known and you have someone in place to carry those out. Separate document is a durable power of attorney or financial power of attorney, but this is someone who will handle all non-medical affairs. This is taxes and real estate, managing business operations, anything along those lines. This will be handled under a durable power of attorney. And a HIPAA authorization is often overlooked, but HIPAA federal law, it ensures that your medical treatment information is protected and private. And a HIPAA authorization essentially allows your medical providers to discuss your healthcare needs with your designated representatives. It's important that they know what's going on if they're going to be in the position of making decisions for you. So a will and a trust, they're two different documents. And one of the most common questions we see is, what's the difference? And they're not alternatives. And a lot of people do think, do I need a will or do I need a trust? And that's really not the right framework to look at these questions. Each does things that the other one does not. Wills do handle more of a fundamental need, and this is things that everyone, again, needs. Trust handles some more complex needs that some people may need, and in California, a lot of people may need, but not everyone needs the additional options that are provided in a trust. Wills do typically act alone. If you have a will, you don't need a trust, but if you have a trust, it is typically paired with the will, and that's, again, because they do different things. And so if you have a trust by itself, it kind of doesn't handle some of the things that you really need as part of an estate plan. You need to complement that with a will. There are some pros and cons. Wills are a little easier to set up, but they do go through probate. They can be public, a little less control over distributions. Trusts give you a little more control, a little bit more complex to set up, but honestly, not that bad. And the last question we hear, probably more than anything else, is when do you need to consider a trust? And this is a great thing that you need to look at your own personal needs and discuss with your advisors. But a few common considerations are younger children. If you have young children, a trust gives you the ability to designate when assets will be distributed. So it might not be on your death immediately or when they turn 18. It might be staggered over ages or based off life events to help kind of stretch out their inheritance. If you have complex family dynamics, this would be a blended family or second marriage situation. A trust can let you support your spouse for the rest of your spouse's lifetime, but also ensure that your assets ultimately pass to your children, not to a remarried spouse or two stepchildren. That you can make sure that you protect your spouse and your kids without having to risk it all being diverted after death. Trusts also, they do remain private. Wills go through probate. Probate is a public proceeding, and so you have inventories and asset information that become public record. A lot of people just don't want that. And so having a trust, financial considerations aside, the added privacy might be worthwhile. And the last thing, it really is higher asset levels. Probate, the threshold in probate California is 166,000. Almost anyone that owns real property in California is going to be over that. So it's really low given California real estate values. But if you have over 166,000, it might be worth having a trust just to avoid probate. But also if you have what you're looking at, multi-million dollar estates, the federal estate tax threshold is pretty high right now. It could lower. It's currently at $11.6 million per individual. But there's talks that it could lower under a new administration. But even if you're not at $11.6 million, if you're over about $5, $6, $8 million, somewhere in that range, you really have a lot of more opportunities for advanced planning, things that you can do to minimize estate and income taxes, and also ensure that your future generations are protected. And I think Barry can definitely give a little more detail on a few of those options and how they might come into play.
All right, thanks, Patrick. I think, and let me just jump in here before we introduce Barry, and just to say, hey guys, put your questions in the chat, and we'll try to answer them along the way. I see some great questions in there for Patrick potentially, but hey, one question, Patrick. So just to really emphasize, guys, this number here, 166K in California. I mean, if you bought a house, anytime in the last 5 years, you should have that. So the point is, like, if you live in California and are a professional and have been working for any period of time, is it true, Patrick, that they should have a trust?
Yeah, that's a general rule. I think that while most states you can take the approach of start with a will and add a trust if needed, in California it's almost flipped. The default presumption is almost every adult needs a trust in California, unless you don't have a high level of assets, don't own real estate, and don't have young children. So almost everyone in California should be looking at a trust. Whether they add it or not, maybe a question for them to consider, but they should at least consider a trust.
Great. All right. I'll turn it over to Barry.
Thanks, Jason. Happy to be here. I am a proud MIT Sloan master's alum, also in San Diego. So I guess the San Diego crowd's taking over today. And as you can see, they needed some gray hair on the program. So I'm on the program to balance off, I guess, geographically in some ways and age-wise. So Jason, if you go to the next slide. So I want to compliment what's been discussed thus far by Patrick. So we've talked about documents, and I want to come from a non-attorney planner background and just offer some perspective in terms of big picture. In addition to my documents, what kind of things should I be thinking about? And knowing that we've got quite a range of people on this call, age-wise, financial situation, family circumstances, et cetera, wanted to sort of a broad overview of different topics to at least give some thought to. Some will be relevant for some of you, only a few will be, et cetera. So when we think of estate planning, I tend to think of it really three general areas: estate distribution, estate tax reduction, estate tax payment. So clearly having the proper documents falls under estate distribution. And I'll add another note, which I've seen over the years, is with some people, it seems to be, okay, I did my documents, I'm done with estate planning, thank God. And they never go back to revisit the documents as laws change or their circumstances change, and they ignore other relevant estate planning issues. So just, I guess, words for wise there. As Patrick mentioned, these state exemptions are up to 11.58 million now. So I think the figure is something like only 3% of the US population faces estate tax under current law. So for most people, getting the distribution in place does enough to eliminate, probate with a trust and using your exemptions. But I will come back to this tax reduction, tax payment in a moment. So a few other things to highlight on this page. One is survivor income in terms of assets and life insurance, which is, okay, if God forbid something happens to me prematurely and I've got my documents, have I left enough for my heirs to survive, meet what we'll call family income needs. And let's say I've got a relatively illiquid estate. Let's say it's a business, real estate, heavily some combination of those two. Where's the income coming from to provide the family and survivor income for a spouse, children, etc.? Is there going to be a need to sell assets to come up with enough income? Again, how do we cover that? Then financial management expertise of heirs. This is one I see neglected a lot, which is I'll see people where they've done a great job of building their net worth, they've got the right documents, but their heirs are clueless financially. And I'll see it a lot with what I'll call type A males, where they're control freaks, they handle everything financially. And what I hear often from our clients is that, everything's fine while I'm alive. It's a disaster when I'm gone because so much is in my head. So this is sort of, not to be preachy, but just a reminder to give some thought to, in terms of financial education, as Don mentioned earlier, et cetera. Do your heirs have enough knowledge to understand how to proceed without you? And in addition, if they don't, are they knowledgeable enough to realize maybe I need some outside expertise? And have you facilitated that process up front? Would be amiss if I didn't just touch on property titling in California, given that we're one of the few states with community property titling, which has a big impact in terms of probate, in terms of impact on step up in basis, in terms of appreciated assets over time. Just a reminder, pay attention to property titling in California. What we tend to see as the happy medium is a living trust, as Patrick mentioned, with assets titled as community property within the trust. And then sort of a personal observation is I've had the good fortune over the years of working with many clients who are real charitably inclined and do wonderful things, giving both dollars and their time to charitable causes and nonprofits while they're alive. And it never ceases to amaze me the number of people, I'll look at their estate plan and the documents, and there's nothing in there for charitable giving. And typically it's, I didn't think of that, or it's, yeah, I'm aware of that, but I want to get my documents in place. And one of these days I'm going to circle back to that and flesh out that part of my estate plan. So the reminder is, if you are charitably inclined, give some thought to what happens once you're gone, and do your documents reflect those wishes. So Jason, on the next slide. Again, some broad level, high level food for thought. I call this the estate planning continuum. And my question is, where do I fall on the continuum? So, and part of this is really identifying, who am I financially? What are my wishes? So the range we'll see is at one extreme, we'll see people saying with dynasty trusts, globs of life insurance, etc., we want to pyramid as much wealth for our heirs, maybe even have them have more than we have today. That's one extreme. The other extreme, I'll see people saying, it's not my problem. When I'm gone, I'm gone. I'm not going to worry about it. And often I'll hear, my heirs are already in line to inherit more than I ever got in the first place without me doing any planning. So for whatever reason, they're getting enough. I'm not going to complicate my life. It's their problem. So we'll see those two extremes, and then somewhere between on the continuum. Well, actually, we see probably most common is, if my net worth is X today, I'd like my heirs to inherit X after tax. So no reduction in what's left versus what I have now. And then, we talk about this is more the higher net worth, is we'll see some people where the question in some cases is, am I leaving too much for my heirs? If I've been really successful financially, is it possible, for example, I'm going to ruin their work incentives by leaving too much? And they're going to be so-called trust babies. And maybe it's not an unmitigated blessing to leave them so much. So for some people, there is that other dimension of thinking about, how much is too much. Doesn't apply to most of us, but for some people, may be relevant. And then my last comment is, in terms of distribution, I find it helpful to think in terms of, big picture, where do I want my assets to go over time and eventually? Where think of it, assets are going some combination of my family, taxes, or charity. As has been said in the past, I think it was Justice Brandeis, as I recall, paying taxes is voluntary to some extent based on your actions. So tying on what Patrick commented on, you, while you're alive, have the opportunity to give some thought to what is the mix that I'm comfortable with, and proactively, to the extent feasible, take the appropriate steps to realize those wishes. And then next slide. Just a sort of high level for those whose net worth is above the estate tax exemptions. Just quick comments here. Some of you, maybe for them, I'll call them the alphabet soup of all the different acronyms, estate planning. And all these in general relate to, if I've got 11.58 million exemption, are there ways to leverage the exemption to shelter larger assets? The acronyms tend to be GRATs, IGITs, SLATs, QPERTs, family limited partnerships, dynasty trusts we'll see in there. Again, since it doesn't apply probably to most of the population, just want to put that out there for food for thought. And then on the charitable side, what I'll call split interest charitable giving, charitable remainder trust, charitable lead trust, where either I give an asset where I retain an income from my life, and the ultimate balance when I'm gone goes to charity, or the reverse with the charitable lead trust. And then finally, estate tax payment is saying, okay, if I've got my proper documents, I've taken advantage of all feasible estate tax reduction techniques, what if I'm still facing estate tax? That's where life insurance very often can fill in, especially in an irrevocable life insurance trust out of my estate tax, out of my taxable estate, for example. We see some people using premium finance and actually borrowing from a bank to pay the premiums for more leverage. And for business owners, there's something called 6166, which says, rather than being forced to sell the business, my estate can pay the estate tax over 14 years. So rather than my heirs having to sell the business to pay the estate tax, they may keep the business and use the ongoing future cash flow from the business to make those payments. And then my final slide, in reference to Patrick's comment about what happens to tax laws over time. This one's a little hard to read at this size, but we tend to think of it as the perfect storm. And some of you that may listen to some of the estate planning commentators out there are aware, for those facing estate tax or concerned that the estate tax exemptions are going to decrease either next year with the new administration, or actually under current law, they are scheduled to sunset as of 2026. But the reminder, the estate tax exemption had been 5 million per donor. Index for inflation got bumped up to double that. So now the 11.58 million going up to 11.8 next year. Under current law, scheduled to go back down to 5 million index for inflation. So some people are saying, gee, if it's going to go down, maybe if it fits my situation, I use some or all the exemptions sooner rather than later. In addition, when I talk about all the acronyms for estate tax leverage, most of them work best in low interest rate environments. Interest rates, as published by the IRS for estate planning purposes, have been hitting all-time lows. in recent months. So again, optimally a very opportune time to take advantage of some of those exclusions and leverage techniques. And lastly, simply the fact that we don't know where the state tax exemptions and rates are going. The rate's currently 40%. As this slide shows on the far right, rates have been far higher. So from a historical standpoint, gift and estate and GST rates are relatively low at the moment relative to historical experience. And on that note, I'm going to turn it back to Jason for some Q&A.
All right, thanks, Barry. So so let's see. Let me go back. This is going to be, it's going to sound like another commercial, guys, but since it's an MIT club event, so I think my tuition was 30 grand a year, and I remember the dean. Well, just to start, I feel like I got more out of MIT than I put into it than I paid, and the reason is because so many people did things like this. So my tuition covered about half the cost of my experience. So I benefited from programs like this and from people before me who donated to the school. But again, it's outside the mission of the club. You don't have to donate. That's just my opinion popping in there. All right, so here's what we're going to do. We created a breakout room. We're going to give you guys a chance to go more on Fintech side with Cody. You can opt into the breakout. You need to raise your hand and we'll move you over there. But while we're getting that set up, I want to give Patrick a chance to explain a little bit more about the pains of probate. So if you guys want to get more onto the fintech and entrepreneurial side and chat with Cody in the breakout, raise your hand, give us some kind of a signal, and we'll start moving you over there. And then I'm going to turn it over to Patrick to answer these questions about well, what's the big deal about probate? What's so bad about it? My assets are above the 166. Why go through this trouble?
Yeah, thanks. So first of all, I've tried to hit as many of the questions I can in the chat. I apologize if I've missed one. Feel free to wave your hands and attract my attention, or just repost your question. I shortened the discussion of probate and just said it's bad. And that's ultimately, if you had to condense it down to one word, that would be the right word to choose for probate. But what makes it bad is maybe worth diving in a little deeper. After you die, your will, your estate goes through a process of probate. The purpose of probate is to essentially ensure that your documents are valid, meet the legal requirements, and handle that transition from a living human into a deceased human, and then the transfer to the additional beneficiaries who take over afterwards. It's largely an administrative process. It's just not efficient. The time from the moment of death, you start a timeline with certain actions that have to occur. In most cases in California, the process will end 18 to 24 months after death. And so that's 2 years that you were stuck going through this court process with hearings and filings and lawyers and just things that most people don't want to deal with. Given the impacts of COVID and the court shutdowns and the backlogs that have built up, it's anticipated that might actually grow from 1 to 2 years to up to 2 to 3 years. So it could be 3 years after death that you don't have final resolution. And what that means is you may not have a total transfer of title to real property. You may not have a full distribution of assets. It can really be a burden for beneficiaries. A surviving spouse may not have the assets they need. It can also be a huge financial hit. It is a sliding scale in California. It is based off the value of the estate. It is based off the gross value of the estate as well. It's important to note. But in a California estate, if you have $1 million, you're going to pay about $25,000 in probate fees, and you can have about that again in attorney's fees. So that $50,000 can be a big hit, especially when you realize that $1 million may be the value of your house is $1 million, but you have a $700,000 outstanding mortgage that you don't get to subtract from that. So coming up with $50,000 can be a real burden. And you unfortunately frequently see situations where people have to sell assets, sell a house, take out loans, use life insurance proceeds, or even sell a business to pay for probate, a process that could have been avoided by setting up a trust for anywhere between a few hundred and a few $1,000s.
All right, thanks, Patrick. We're going to continue with the Q&A. If you guys want to move to the breakout, you got to let us know. Raise your hand. Give us a sign. We've got a few minutes of Q&A. Then we'll bring everybody back. We'll wrap it up. This is the recorded part of the event, and then actually they volunteered to stick around an extra 10-15 minutes for some more Q&A on the unrecorded side. So if you're shy or got more questions, you'll have another chance after 1 when we do the formal ending of the event. So anyone got any more questions? I think actually while we're figuring that out, hey Patrick, there was another one about out of state. From Paul had asked a question about, you set things up in California, then you move out of state. What do we got? Any tips?
Yeah, so generally, once you set up an estate plan, as long as it's valid in the state where you created it, it will remain valid in another state. The other states will continue to recognize it. So you don't necessarily need to create a new will or draft a new trust just because you move states. It may be worth considering it. Any major life events, kind of a trigger to reassess your estate plan, and an interstate move may be one of those life events. So you don't necessarily need to make a change, but it's probably a good idea to just pull out your documents and look at it and say, is it time for me to make an update because I've moved states?
Ellen, you want to ask your question to the group?
Yeah, can you hear me okay?
Yep.
Yeah, I just have a question about trustee, because that's a pain point, right? If the trusts are all private data, not recorded anywhere, and well, I've seen recommendation where you should even keep the trust private, away from your beneficiaries, except for the reason like not to spoil your children, or your spouse may have ulterior motive, whatever, right? Worst case scenario. So if you keep all the trust data private and then you have a trustee, and I've been investigating, those trust companies charges $5,000 minimum and tens of thousands of dollars, like a basis, a point basis, based, a fraction of your overall net worth, right? It's really expensive to maintain. But if you just ask a friend to be your trustee, and that friend might go through life-changing events himself or herself. So how do we, it'd be great if you also offer some kind of affordable trustee service who can actually execute the trust, because it's also a moot point. You move all the assets to trust, but no one can find it. There's no second copy around. So do you have any insight into how people manage their trust effectively without getting lost in the shuffle?
Yeah, I don't know if Cody's still here, but I'm sure Cody is pumping his fists because moving into trust administration services is definitely on our roadmap. So that's something we're actively looking at. When I say trust keeps assets private, to clarify, your beneficiaries still have a right to know information once the trust becomes irrevocable. So essentially, once you die, there are legal duties the trustee has to provide information or a copy of the trust to the beneficiaries. And those beneficiaries, they have a right to monitor the actions of the trustee and inspect that. And if necessary, they can file a petition with the court to say, this trustee is acting inappropriately. Can the court step in and correct this behavior? You are absolutely correct that there is a bit of a risk that the trustee could just pocket the money and abscond and buy a new boat, whatever the case may be. But there are legal procedures in place to help prevent that type of fraud and embezzlement, the same way that when you deposit your money at a bank, you trust that the teller is going to stick it in your account and not just in their pocket. The corporate trustee is an increasingly common request from individuals. Still, the dominant majority of people choose to have their trusts administered by their spouse or their family members. Those individuals can always consult with an attorney or a legal advisor or a corporate trustee if they need some additional help, but they don't necessarily need to be bound to pay those $5,000 a year. Some corporate trustees charge a fixed percentage of the assets. That being said, a corporate trustee can absolutely be a great choice for a lot of individuals who have complex needs, complex family situations, or just want a little more, confidence that their trust is going to be carried out in the way they have instructed it to be. Barry can probably add a little information on that as well, but it's definitely increasingly common to see people look for a corporate trustee.
Yeah, I was just going to jump in. Full disclosure, I am employed by Northern Trust, which is a trust company. Piggybacking on Patrick's comments, it needs to be the right situation for corporate trustee. I mean, I can tell you, Northern has lots of situations where we decline to be trustee because from a cost benefit standpoint, it's just not in anyone's best interest. And so from that standpoint, we'll just we'll make some other suggestions. And as Patrick mentioned, yeah, where corporate trustees fit, it's going to be more complicated situations. Very often it's illiquid assets. In some cases, some or all cases, it's heirs who don't get along well, or I'm thinking of a couple of situations. I'm thinking of a movie producer where he clearly knew that his daughters were going to spend everything that wasn't nailed down. And they've shopped trustees, trying to move who the trustee is, trying to get someone who's most lenient in terms of distributions. So again, it comes back to my, my slides of upfront thinking through, who are you? What are you trying to accomplish? And what are your needs?
Okay. Well, I'm just talking even somebody like a central repository place to keep formal documents, because I read somewhere, don't lay your trust and will around, because again, you don't want to spoil your beneficiaries, right? You don't want your children to know they're going to be trust fund babies, right? And even your spouses. I mean, it's just kind of want to isolate that. So I'm just concerned there's not even a second person who has access to the proper documents. If you just, because what if the trustee doesn't survive either, right? And then again, who do you pass that to? Somebody has to be able to execute that, with integrity, but also accurately according to the trust. So I think creating a trust is great, but it's the executor of the trust I think matters even more sometimes.
Absolutely. And part of, well, I see a lot of times maybe the CPA or the attorney has a copy of the trust where it's some other person in the family. And just a quick war story. Many moons ago, I was working with a UCLA grad, and he'd prepared a trust. He was really proud of it. And I happened to ask him, your executor and trustee, are they aware that you've named them in the documents? No. Do they have copies of the documents? No. Well, if something happens to you and you're gone, how are they going to know that they're executor or trustee? Oh, good question. True story.
Right.
Well, hey, I gotta jump in, and we have time for more Q&A, but that'll be after we wrap the event. There was one question I think that kind of overlaps with a number of the ones in the chat, and then I'll give Cody a chance to share anything he wants for the group. And then also Barry Patrick will let you guys do some final comments. But the question is there any reason not to have your assets in your trust? For example, whether they're out of state or it's a home or otherwise, are there checklists? And again, I realize there's just any kind of high level, any comments on that?
My take on it is any asset that would go through probate, it's generally worth putting into your trust. There are some assets that would bypass probate. If you have a bank account with a beneficiary designation, it might bypass probate. So you don't necessarily have to put that account in, but there are benefits to having that account in a trust. Whether it's protecting in case of incapacity or the risk of a faulty beneficiary designation. But there are very limited exceptions to when you might not want to put an asset in a trust. Retirement policies, you typically should not transfer in because there are tax consequences of that type of transfer. And maybe there's a weird quirk with your auto insurance where having the title of your car in a trust. Some insurance companies just don't handle that well. And so maybe you leave out a car or something like that. But as long as you're under that 166,000 threshold, you're generally okay. But most of the times, every asset should go in the trust. There are some exceptions, but they're fairly limited.
Patrick, what about digital assets? Everything from cryptocurrency, your photos, email, any digital assets, social media profiles.
Yeah, the largest issue with that is the ability to transfer it into a trust. You'll find that some of the crypto wallets may not have the ability to have a trust ownership, things like that. So you may have limitations on the ability for that particular provider to transfer ownership into the trust. And social media, yeah, you can put it into a trust. It's a little, the process is still in development, I think is the nice way of saying that. But there's a little bit of work to be done to make that process seamless. And again, while most people, I mean, my MySpace account is not worth $166,000, but a lot of people who do have social media followings, it's worth for them considering whether they want to transfer that into a trust or set up some sort of business to hold that equity asset and then have the business owned by the trust as well. So it's definitely worth getting it in if it's any significant value.
I just want to say, I noticed in the chat box, there's been a few questions about Prop 19. And just to clarify, I don't have all of them in front of me, but there's a couple of topics there. There's income tax basis versus property tax basis. So I find a lot of people get confused on that. So Prop 19 has to do with, to the extent I can carry over, my heirs can carry over a basis either on my home or non-residence properties. The wrinkle is, if you've got highly appreciated assets, any asset you gift while you're alive, they keep your income tax basis and don't get a step up in tax basis, as opposed to going through your estate, they get the step up in basis. So again, don't have little time to go over that, but just be sensitive to the fact that there are trade-offs there on that topic. And if I want to elaborate on that, Patrick.
Well, let's pick that up after the break. Thanks, Barry. That's actually, I got a question on that too, and we'll pick up some more of these questions in the chat. Patrick, final comments for the home audience, the recording.
Yeah, I think everyone needs an estate plan. And a lot of people have a misconception that they may not need a plan, or their assets aren't high enough, their situation is not complex enough. But estate planning is for everyone. It's not something you do for yourself. It's something you do for your family. And, you know, trust and will, we try to make it an easy option for as many people as we can. But if we're not your solution, find an attorney, call someone else. But give some thought, put a plan in place, and do it for your family.
All right, thanks, Patrick. Cody, did you have anything more to share?
No,
anything out of your breakout?
No, I just want to say a thank you to the group. Yeah, in the breakout, we covered a little bit on how we navigated the state-by-state regulatory requirements over the last 3 years, along with how we tied in the venture funding that we've raised at each round, and how the team has grown from 3 founders to a team of 5, now to 24, and we'll be doubling headcount over the next few months. But it's just really grateful for the group's knowledge and questions.
Wow. All right. Well, I want to thank everybody for coming here. It's 1 o'clock, so we're gonna stop the recording now.